You made your entry. Okay, so we're live then? Okay. So welcome everybody, both here in the room as well as our online attendance. Let Shirley know in the chat function if you're having any difficulty hearing me. My name is Rick Snyder, and I'm going to be doing the class today. Is everybody okay on hearing me, Shirley?
No answers yet.
No answers yet. Okay. So I'm going to sit down. Hopefully you guys can continue to hear me online. I know here in the room that you can hear me. I want this to be a process of both education, but one in which we're engaged in a discussion, almost like we're all involved in the same company. And you have an opportunity to ask questions during the course of the presentation. So I want it to be interactive. The people that are here, just raise your hand and I'll finish whatever thought that I've got going on, and then I can ask you to state your question. I think because I'm closer to the mic, that I may repeat the question for those people that are online. And if there's people online that would like to ask a question, just go into the chat function. Shirley will raise her hand, which is one of the few times that I make her raise her hand to be recognized. And she'll ask your question of me so that I'm not trying to look at the screen itself. We're going to really separate the area into three areas, and I'll get into the slide presentation itself in a moment. We're going to be talking about law changes. We're going to be talking about form changes from the California Association of Realtors. And we're going to be talking about some of the statewide law and local ordinances that are impacting on the rental housing industry. So we have a lot to cover in 2 hours, just because this environment has gotten more complicated. For those of you who do not know me, I'll give you just a short bio. I sometimes joke with my staff that, and when I'm doing other talks, that my resume is like the chronicle of an overachiever, meaning I've done way too many things over too long of a period of time. I received my real estate license when I was a senior in high school in 1974. So in 2024, I will have been in the industry for 50 years, which is ridiculous. But during that period of time, I've been president of the local association. I've been president of the California Association of Realtors. And this next year, I'll be president of the National Apartment Association at the national level. I'm a certified property manager. Jessica, who's with us in the room today, is in charge of our legal department. We manage approximately 7,000 multifamily units. So we have a large company. There's 220 employees in the entire company. So how it got this big over this period of time is remarkable to me. And it's gotten to the point where I don't know everybody that is in the company, which is not good, but that's the way it goes. So we're at the front line of dealing with a lot of these issues. And one of the reasons why I like doing the class for the association and for Shirley and for all of you is I want to share with you the perspective that we're experiencing and how we're, as the title indicates, successfully navigating property management in this environment. Because I've never seen the amount of regulatory activity, the amount of law changes that are going on at the local, state, and national level in the entirety of my career. And I used to say that the complexity was, as professionals in the industry, was our friend, because our principals, our clients really needed our assistance in order to navigate through this process. But as we talked just before starting the recording and starting the class, this environment is getting even more problematic, even for professionals, to stay current with the environment that is going on and the law changes. Let's see. The clicker's not working. Oh, here. No, that should be it. Can you do it from your computer? James, the clicker's not working.
I heard you.
James saves both me and Shirley from ourselves. So while James is helping us with the technology, because we have so much material to cover, it'll be fast paced, but I really do invite your questions. I think it's important.
I'm sorry, you should have, yeah.
Oh, the old fashioned way?
Sorry.
Good job.
So-
No, that's not working either.
Okay,
How's that, James?
beautiful.
How's that? Can I use that?
Hold on a second. There you go.
There we go. Yay, James. Thank you. So in the first part of this, we're going to talk about condos. We're going to talk about reusable tenant screening reports, termination of tenancy protections for victims of domestic violence, and a study that's commissioned to look at leases and rental agreements. I should mention to you about that last topic that I was invited to participate in a study group for the California Association of Realtors in modifying their forms. So in the property management area. So if there are changes to the forms that you're seeing here, you will see. I'm partially responsible and I'm at fault if you don't like them. So let's go there. Okay. We're also, as we talked about, we're going to talk about in these forms, the new rental property owner disclosures and some of the other revisions in the property management agreement. But let's talk about first the issues regarding the right to rent. And for many of you who have sold condominiums in the past, you know that many of the homeowner associations have had a restriction on the number of units or the duration of tenancies that are allowed under a common interest development. And one of the requirements that you'll see in green is that an HOA cannot prohibit less than 25% of the separate interests to be rented out. So they can't prohibit. Now, as you know, if you've done financing with FHA, especially, but also with VA, they will many times have restrictions on the numbers of units. And they don't like to see over 50% of the units rented. And but some HOAs have taken the position in their CC&Rs and their bylaws to completely eliminate the ability to rent. And this state law in AB 1410 provides a preemption against those CC&Rs that compels the HOAs to conform to state law, notwithstanding what their CC&Rs say. So that's first and foremost. And this is all part of the state initiatives that are going on to increase the availability of housing within the state. And that's one of the reasons with density increases that are going on for new development. This is one piece of that puzzle. Increase the number of units that can be rented out in a unit. So that if you're representing a potential buyer in a property or you're a listing agent on a condo, you should be knowledgeable about this 25% issue. And it would be beneficial to inquire of the management company of the HOA where they are on their percentage related to rentals. Because if you're representing a client and their interest is to rent out the unit, it would be a material fact if they're already exceeding the 25% or what the restrictions in the CC&Rs are. Right? Again, this is just part of the complications. So that's one issue.
I do, so I'm a little confused, I'm sorry. They
Let me
still-
go back. Go ahead.
So if it is, cannot prohibit less than 25%, so they still have a restriction on it. Their owner occupancy rate must be less than 25%.
Yeah, so the question is that regarding the restriction. There was an awareness when they drafted this bill. That certain federally funded lenders, such as for FHA programs. Require that you can't have over a certain percentage that are rented on a homeowner association. And so this was a middle ground. I think this was a compromise. That said, we're not going to get close to that 50%, but we're going to require, notwithstanding what's in the CC&Rs, that you must allow up to 25% of your units in your property that would be available as rentals.
I got it. Okay, that makes sense.
Yeah.
25%.
25%.
There was I know a bunch of complexes, they had 6-month minimums, and all of a sudden when did this pass where it said you can't restrict beyond 30?
Just recently,
Right,
just recently.
okay. Are there HOAs that are pushing back on this or not complying?
I don't think that, so the question is, were there HOAs that are pushing back in this political environment? Good luck. If they are. I don't, this is now state law.
Well, they sometimes not even aware of some of these things.
Correct.
Talk to them. Yeah.
That and that's one of the reasons why we're doing this class,
Okay.
so that you are aware, because this potentially creates business opportunities for you. It also provides greater flexibility potentially to current owners within a HOA, where those restrictions were more restrictive, and now they have the ability to rent out those units. So let me go through this on the reusable tenant screening reports, and you can see what's on the screen. I think one of the things that I want you to know is that there is an all of government at the federal level effort to provide enhanced tenant protections to residents in properties. And one of the things that they are trying to do, government is attempting to do, is to create more of a level playing ground between the landlord, and you'll see later in the presentation that there's probably going to be law changes to change the vernacular associated with the relationship of what has traditionally been viewed as a landlord-tenant relationship to a housing provider. Used to be landlord. And this is not settled yet, and I'm getting ahead of myself a little bit, and to move from a tenant to a resident, as an example. And so part of this is that they want a more consumer-friendly, consumer beneficial relationship between landlord and tenant. And that part of this is that they want to create, this is an AB 2559, a reusable credit report. So that if the credit report is obtained by the tenant, perhaps from one apartment complex, but for whatever reason, tenant decides not to take that apartment, or alternatively, that landlord decides that they've already rented the apartment to someone else, that within 30 days of the issuance of that report, the tenant would be able to transfer or utilize, provide to another landlord that report that would then enable that tenant potentially to rent and not have to pay duplicate fees for credit reports. So this is a new law as well. Now, one of the things that you should know is that the state of California through the legislature is more proactive than any other state in the country, perhaps other than Illinois and New York. But a lot of these progressive laws is much more active in California than it is elsewhere. So if you were to talk about this reusable tenant screening report with any of your friends in other states, they would not know what you're talking about. And yet this is the effort that's coming out of the federal government to be promoted all the way through the country. It's just that California is ahead of the process.
Well, Zillow's been doing that for a little while. You pay a $29.95 fee, and for that entire month, whatever apartments that you apply for, they transfer that information over.
Correct.
So they already have that in place.
So, and I think that what we're gonna start to see in the industry, which will ultimately be beneficial, is to have a one size fits all format of the tenant application. And the same thing that would go through in the tenant screening report that's received from a credit agency. And my company and many others use a algorithm. We use a tenant screening company that applies our standards regarding 8 different factors. And then we get back results that say accept with condition, or reject based on the application and credit report. But I think what we're going to start seeing is that the credit report that is received by the tenant for property one, that then comes to our property, can be electronically communicated into our system and then processed at no additional cost. And I think that's where we're going to go.
What do you do, or what have you done in the past when a tenant asks, they may have been denied, but asked for a copy of the credit report that you read?
We provide it, and we'll provide the reasons why, to the degree that we know.
Okay.
Yeah,
Yeah, that's what I've always done too.
yeah, it's just the best, because you want to empower the people with the information. So the issue with the reusable tenant screening report, a landlord may elect to accept the reusable tenant screening reports or not. If the landlord does accept the reusable tenant screening report, the landlord may require an applicant to state that there has not been any material change to the information in the reusable tenant screening report. I think it's important to know that this is in its infancy. This is going to evolve over the next 12 months. But just expect that this is we're going to see some significant changes in the industry about this issue. And it's because there was an argument or complaint that some landlords were doing credit reports, using it as a profit center, and having 5 or 6 or 10 applicants come in only to select only one, and then those other remaining 9 would then have to go again and pay a fee again. And they want to take those kinds of abuses out of the system. So I think it's for a good reason. The industry just has to come up with an appropriate way to comply. So I think it's a good thing, but it's going to be evolutionary in terms of what we deal with. So the next area is regarding landlord tenant and termination of tenancy protections for victims of domestic violence. So this is a change. It is something that many companies have already dealt with. This is a evolution out of the Military Soldiers and Sailors Act. And the reason I bring that up in that context, if a soldier or sailor gets notice of requirement of the duty station change, then you're required without penalty to terminate the tenancy and allow that military member the ability to provide notice and to vacate the apartment without any penalties. In the same way, this is my view of this change regarding domestic violence, is both on this page and on the next one slide, you'll see that they codified in SB 1017 the ability for victims of domestic violence to be afforded the same basic protections under the Soldiers and Sailors Act to be able to vacate without penalty. Now, in my view, both in this page, and let me go to the next page. There we go. I don't know that this goes far enough. And the reason I say that is that I just want to say to you that if somebody, well, let me back up. We're all aware of what's going on in society. society seems to be getting more violent, and people are acting out in ways that 10 years ago, 20 years ago, we didn't see to the degree that we're seeing today. We take the position in my company that if an individual indicates that they are the subject of domestic violence, then we are taking the position that they don't have to show us the evidence that is prescribed in the statute. We simply let them leave without penalty, and we provide them with the entirety of their security deposit back. Why do we do that? We do that because we think it's the right thing to do. Let's start there. But the second issue is if there's a requirement to show a court order or other documentation to support a protection order, and during that period of time from when that tenant first notifies you to when they're have the ability to move out, if they are assaulted, much less potentially killed, then the argument could be made by the courts that you didn't act reasonably or in a timely manner just to help protect the tenant from that domestic violence perpetrator. And so we take a very proactive, aggressive posture that if somebody comes to us and says they've had this problem, this person assaulted them, they feel in fear of their safety and they need to relocate, we allow them to go. And I would just urge anybody in this class to follow the same, what I would view as a responsible course. So just be aware of that. Now they talked about getting a copy of the temporary restraining order. This is what's in the statute in SB 1017. But again, my urging to all of you is that you just let them go out. Now we have a different issue, which is where there's a termination of a partial eviction. This is trickier. So this is where the person that is the recipient of domestic violence wants to continue to reside in the apartment, and they want the locks changed, and they want a termination of tenancy of that individual who is the perpetrator of the domestic violence.
Who actually lives there too?
Who actually signed the lease and lives there. Now, you would think to yourself, but I've never had that, and I don't even know of anybody else that has ever dealt with this kind of situation. I'll just tell you, because of the number of apartments and situations that we get involved with, this happens more often than you know. And so in that case, you do need the court order. And our urging to the tenant is, if you're in fear for your safety, then we would urge you to move out, but we give that to them as a choice. And that's something that I'll just mention to you. This is regarding habitability issues. This is regarding environmental issues. If there's a substandard condition or a situation like this occurs, we find that many times people will get angry because of whatever the situation is. And that anger is really about fear, because anger is a manifestation of fear. And so what we want to do is get to the heart of the issue about the fear, and how we can best approach the issue of fear is to give people a feeling of empowerment where they have choices. That is the number one most important component of this. So we will communicate verbally to them about the choices that they have available to them. We'll confirm that in writing with them. We ask them to confirm in writing their election, what they're electing to do. And once you give them choices regarding the course of action that is best fit for their individual needs, you've just gained an ally. And you are collaborating with them on the best solution that is going to fit their needs. So be mindful about that when you're interacting with residents, that to the degree that you can create a collaborative environment where you're jointly solving whatever the problem is together, where they feel empowered, not subjected to the vagrancies of what is happening to them, but they feel the empowerment of the ability to act on their own volition in concert with you, not in opposition to you. You just want it. And you can work forward to a solution that's going to benefit everybody in the situation.
Okay.
Yes,
Are you saying that you don't usually have issues from both of them? I mean, you have one person come to you and then the other, the victim and the perpetrator?
you can, I'll just give you my experience, because you asked the question. My experience is the perpetrator of the alleged, and you heard me use the term alleged, domestic violence is not the one who's coming to us. It's the one who says, I'm the victim of domestic violence, and I'm asserting that that's what's occurred to me. And so many times I don't hear from the other person who's the perpetrator. But what we'll seek to do, we think that is in the best interest of everybody, especially if the police have been called and it's disturbed what's called the quiet enjoyment of the other tenants that are in the property, that it is in the best interest of everyone to terminate the tenancy and allow the parties to go their own ways. And we'll do that by accomplishing it with no requirement of a 30 days notice, a return of the entirety of the security deposit. We ask them to leave the property, the unit in broom clean condition. They both vacate and will return any unused rent. Because we want them to go their separate ways and enable them to do so. I think it's really important. I think people, landlords especially, have a tendency of saying, this is not my problem, this is not my issue. And by golly, I'm not going to give them the benefit of the entirety of the security deposit, waiving 30 days notice requirement. But at the end of the day, if somebody gets hurt, if there's other issues that go on, you're going to end up in a lawsuit that's going to cost you far more.
The liability of our sugar society today,
Yeah.
That's the right thing to do.
I think that it is the prudent thing to do,
Yeah.
and I think from a moral perspective, it's the right thing to do.
Also,
Yeah, it's that old adage of do unto others as you would have them do unto you if you were in that respective position, which still is timeless, and it still is so true that I sometimes think, and this is where I've come from, if that was my daughter or my son or my grandchildren, how would I want them to be treated?
Yeah.
And that's how I would urge everybody to approach it.
Explain to the landlord.
Yes, yes.
Okay.
So, now this is something that I talked about before, and this is AB 2503, and this is to be completed by the end of 2024. This has been part of the whole of government. You know, you probably read in the press that many terms are being changed. So the landlord-tenant relationship is yet again one of those areas in which they're looking to change the vernacular. And so instead of landlord, lessee, lessor, management occupant, I think where they're going to land is on housing provider for the landlord and resident, for the tenant and landlord-tenant current relationship. But this is something that the industry is providing input to, but ultimately, this is a state government change to the law that they're going to implement. And so we don't know what it is going to be, but it is coming. So just be aware of that. So let's then get into some of the changes regarding the CAR forms. This is a pretty significant change, and I will share with you that this is oriented so that you know to 1 to 4 rental units, and it's really oriented to single family homes and condos. But again, it would be most applicable to up to 4 units. And when I was on the study group, I was somewhat against this because what they were attempting to do was impose the TDS requirements that's on a transfer disclosure statement for a sale transaction into a disclosure from the owner of the property to the property management company, very similar to the TDS requirements. And going even into the SPQ, the seller property questionnaire. And the argument that was advanced in the study group was that we're imposing certain requirements on licensees in a sale transaction environment. Should we not have the same benefit accruing to a property management company from the owner of that property so that it enables the property management company to be in a position of fully informing the resident and themselves about the issues that have gone on in the property. Again, to share with you, I was opposed to this. We made certain modifications to the rental property owner disclosure. And I'm comfortable with it now. I will say to you, because most of our properties are larger, do I use this form? No. Is it a required form? No. I think, is it beneficial to be provided by the owner of the property to the management company? The answer is yes. So my urging to you, if your focus is on smaller properties, residential 1 to 4, including condos, that you use the form. And I'm presuming for both the people that are online as well as those that are here in the room, that you're largely using the CAR forms. And so that's why I'm going through these. But also, I think it's important, even if you're not using the CAR forms, many experts, and that's one of the things I didn't mention, is that I do an extensive amount of expert witness work for real estate standard of care. There will be experts that will opine that the CAR forms are the gold standard regarding especially transactional forms. They'll make the argument that it's also equally true on the property management side. I would beg to differ with them on that topic. But when this is becoming or comes into common usage and you're not using them, it can be problematic. So my desire or recommendation is that you do use the forms. And I'm not going to go into specific detail about that, but you can see when you look at the questions, it looks like a TDS or an SPQ, right? It's fashioned after the same type of document. And at the end of the day, it provides interesting information, especially as to who's responsible for certain things, especially in a condominium environment, in an HOA environment.
I think it protects the property manager too.
I think it does too, because then you're relying upon the disclosures of the owner, which you don't, much like in a sale transaction. If the seller is making an affirmative representation regarding certain conditions in the property, and I testify on this all the time, does the property manager or the agent in the sale transaction, are they required to investigate the valid nature of whether they're true or accurate or not? And the answer is no, they do not have the responsibility to investigate. They can rely upon the representation of the seller through the TDS and the SPQ. So that's an important distinction. So I think at the end of the day, it's going to be beneficial. But you can see that this form is going to get into a whole series of issues from Prop 65 all the way down to laundry room and appliances and mailboxes and keys. So I think in many respects, it's very beneficial. And if the owner of the property doesn't know, they don't know. And it's okay for them just to say unknown. And it'll be interesting next time I do this class, if you come back to the class, if you found it valuable, it'll be interesting to hear what your experience has been using these forms, whether you find them to be valuable or not. But again, it's not statutorily required. This is something that the study group came out with the change in as a new form. You'll also see, we spent a significant amount of time with the property management agreement from CAR. And so you'll see a number of changes regarding this. And I think that the changes are really good. My recommendation is, because the laws are changing so frequently, I would urge you to review this agreement if you're, whether you're using it or not, the CAR form. I would urge you to review the property management agreement. And if it meets with your understandings of the nature of the relationship between you and the owner of the property, I would urge you to use this form and update your current management agreement with the owner. Because the laws are changing that significantly. I got them, although it's not in here. There's a provision within the property management agreement regarding the indemnification clause in the new management agreement that I got them to change. And it's something that has saved me a number of times in order to ensure that the property owner's insurance takes the lead on providing insurance defense both for myself as a management company and the owner of the property. And that's now embodied in this new management agreement.
I did.
So if not for any other reason, I would urge you to carefully look at this management agreement. And I would urge you to send out the new management agreement. So that's on the management agreement. Any questions regarding the management agreement? No questions on chat so far? Good, I think you're doing a sterling job.
You say the RPOD is optional, but I think it's incorporated in the PMA when you bring it up now.
It is.
So really, if you're filling out a PMA, the RPOD is gonna be there.
If you fill out the new PMA, new property management agreement, you're right.
And does this have now an early termination clause automatically?
Yes, sure does. And let me, so you brought up a good question. I was wondering if anybody was going to catch that. So yeah, thank you. We have a provision in our agreement. Our term is for a period of 5 years. We do that because we don't want to have to renew the agreement and have it go on in a month. But we have an express provision that the our management agreement can be canceled on a 30 days notice without reason. Why do we do that? I'm seeing more lawsuits focused on management companies for failure to perform, where the management company resists the termination and early termination, arguing that they are performing, notwithstanding the owner of the property's view that they are not. So from my perspective, one of the ways for the owner of the property, if they wish to terminate the tenants or the management of the property, is to simply terminate the management agreement. And again, with this thought about enabling, empowering, I'd rather have their ability to terminate the agreement if the relationship for some reason has gone sideways. The ability for either party to terminate the agreement. Now, I will tell you, and it sometimes doesn't make sense, when you work hard to establish management agreements and management for properties, people change, relationship changes. Sometimes the ownership will go from one generation of a family to another, and that new generation philosophically is not in alignment with our business model. And I want, candidly, notwithstanding the term of the agreement, to cancel the agreement because it's not working for me. So the 30-day notice requirement is a two-way agreement for termination.
It's more important for me,
Yeah.
actually. I don't like to stay in relationships that aren't working.
Agreed.
I agree.
I agree. So it does have that automatic provision. I'm the one who made that recommendation. So if you don't like that provision, it's because of me. Because I just think that much like the housing provider resident relationship, the owner, property management company, you want that same level of flexibility in the agreement. I think it's gonna better serve everybody.
It's a good thing. It's a good thing.
It's a good thing. So in the same thing going, so you'll see, here's the in-depth, no, it's not actually in there, but these are some of the new sections, and so the management agreement has really changed. So go into the forms, take a look at the new management agreement, and it'd be interesting to see what your feedback is, but we spent more time on this particular document than we did almost on anything else.
The red.
Lots of red. So we also made significant changes to the listing lease agreement. Because of the size of our company and because, in my view, the CAR forms are more oriented to single family 1 to 4 units, which is not the typical projects that we're involved in. I use a local law firm for larger complexes called Kimball, Tyree, and St. John. I'm not saying that by way of an advertisement for them, but they've got an excellent lease that I pay on an annual subscription basis for that are better for multifamily. But there are so many law changes that are occurring. My recommendation is that you also look at this new lease agreement and that you look at these forms are being changed on an annual basis, especially the lease agreement. And because this environment is so rapidly changing, my view is that the relationship between yourself as the management company and the tenant, that a new lease should be executed, even if they're on a month-to-month basis every year. Every year. And just
A new lease?
a new lease. Yep.
Now, because the forms are changing so quickly,
Yes.
not just an extension.
Yeah. Again, one of the benefits of
I've
me,
been doing extension.
yeah, and that's why
Just,
one of the benefits of teaching a class like this, I get to have you be the beneficiary of my experience. Whatever I say, you can take for a grain of salt. It doesn't matter to me whether you do it or not. I sometimes will forcefully argue about it, the issue, or urge you strongly to do it. We used to do extensions. We used to do just a letter saying your current lease is basically still in full force and effect, but we're giving you this notice to change the rental amount. And in the current environment, and I think we've been doing this for the last 5+ years, it's not adequate anymore. It just isn't. The laws are just changing too fast. It's like the example that I would use to you by way of a good example. It's like saying, well, I'm really used to, and you know that we just changed the RPA,
yeah.
right?
Mhm.
That's like saying, well, I'm really used to the RPA that I've been using for years,
I don't want to.
and I don't want to change. How do you want to get in trouble? How many ways do you want to get in trouble? And it is using that example as the best example that the RPA is constantly changing and evolving. And so when you go in to do a new purchase agreement, you're going to have the new updated laws. And so then my challenge to you is, if you're willing to accept that in the purchase agreement environment, why wouldn't you apply this in the same manner to your lease agreement with your resident?
And
It only
if you
makes
have a-
sense.
what if you have a 2-year term? Still, you can't update your lease in the middle of a 2-year term.
Actually, what we do, which is kind of interesting, so the firm that we use, KTS, when there's a law change, if they're on, first of all, I don't do 2-year agreements.
Okay.
So
I know.
let me start there. But so when they come up for renewal, we just give them the new lease. But when we've taken over, this is another interesting issue that I'll just mention to you that I hadn't planned on saying, but I'll say this to you. If you take over management of a property and they have a really bad form of lease that is on there. And let's say that they're on a 1-year lease and you have 6 months left to go. I'll say to them, we'll send them a current copy of our lease. We'll say to them, we acknowledge and understand that you have a current lease that's up for 6 more months. But I want you to know that this is the lease form that we're going to administer your residency at the property under.
Oh,
In 6 months anyway.
now,
Now, and this is the lease form that will be utilized on your renewal of the lease.
You know,
And the reason I do that is sometimes there's a thing called disparate impact regarding discrimination. And they'll have rules and regulations in the current lease that have substantial and real, sometimes very negative restrictions on the tenants, the children of residents, use of the facilities and the property. If I administer the lease under those terms and conditions of that old lease, I could be found responsible for that disparate impact. I just use that by way of an example. And I just want the tenant to know that these are the new rules and regulations. These are the lease terms and conditions that we're going to administer our management of the property on. We're acknowledging your current lease form, but this is the administration that we're going to engage in.
but that's the company that you use.
No, this is me as a company.
But the company that you use with the lease agreement.
So let me use this as by way of an example. If I apply the same situation and we know that this listing, this lease. And actually, this is on the lease listing agreement, so let me just deal with the lease for a second. If CAR comes out with the new lease, I'm gonna use that new form when I take over a property and tell them that this is the form I'm gonna use.
That's what I wanted to know.
Yeah,
you know, you use an RVA once. If you're gonna be, it seems like quite an onerous data input. Drill to be constantly updating leases. At the end of the term of a tenancy.
so there's softwares that are out there.
That will autofill it.
Yes,
Okay.
yes. So we use RealPage, but it's for bigger companies like ours. But Appfolio, as an example, is a good one for smaller companies.
I use the template, I use that fully on.
Okay, and they've got a lease form that's in there.
I use the card forms.
Okay, great. And so it'll auto-populate, yeah. So that's what I would recommend that you do. I come from a perspective of not what the custom and practice or the standard of care in the industry is, but what I'm promoting as potential best practices because it's proven. So I want to draw that distinction. In telling you what I'm telling you, I'm not attempting to say you have to do this, but I'm indicating to you, based on my experience, that it is the prudent practice, the practice that is the best practice that I would encourage you to engage in.
Liability protection.
Risk management, yes, it is. And just to put this in context, the average expert that does standard of care related issues, and Jessica, who is here in the room, helps me with this. The average expert has anywhere from 2 to 5 cases that are involved in as an expert witness at any one given time. I think currently, right now, I've got 130. I know. But I also have 4 people working for me doing nothing but expert witness helping me. And so I see how one of the benefits of being involved as an expert witness is I see how other people get in trouble. And it's benefited my company, and hopefully through this, I can benefit your company and yourself as an individual. To be able to incorporate best practices so that you don't have the same problems that some of these other companies have been involved in. So you get to be the beneficiary of that. The lease listing agreement has also changed. So this is a situation where you're not necessarily managing the property, so you're not doing a PMA, but you as a real estate agent are listing the property to lease. And so this has changed as well.
Rick, I'm sorry, but you didn't answer my question
Which one?
about the 2-year lease.
If you
said
have
if
it,
yes,
I'd still do the same thing. I would still give them the new lease form
okay,
and say, this is how you're
in
administering.
between.
Yes.
Not a 1 year.
Yeah.
Thank
And
you.
I hope I got to this point, Geez. Thank you for doing that. That we automatically go out with the new lease form when we take over a property.
Oh, yeah. I can
We
see.
automatically do it. And we give the preamble. We understand your lease is in full force in effect, but we're going to, this is how we're going to administer the property.
But you're not using the RP OD.
If I was using, I'm not. That I'm not using the disclosure form. But, and I. In all the fairness and disclosure, I created my own management agreement. So it's particular to my company. But I still think that the property management agreement that is promulgated by CAR is an excellent document. And through these recent changes, it's only gotten better.
Thank you.
So you can see the various changes that have occurred on the lease listing. And here's the residential lease agreement, and you can see that the language has already changed to housing provider. It still says tenant, but I think that that's going to be changing under the new law by the end of 2024. So this is another one where if you're using the CAR form for a lease, we went through and did quite a few changes. This is the application to the lease form itself. And I would urge you to really look at it, see if it still conforms to your business model within your company. And then I would recommend that you contemplate doing what I'm suggesting on the lease itself. Now, on the bottom, it says this limit
Maximum amount of security.
on advanced rent.
Cannot exceed 10.
But it also allows on payment via electronic apps such as PayPal, Venmo.
Nice.
So it provides that in all of our,
We don't have to write in.
right. In all of our company, we facilitate electronic payment.
Mhm.
They go onto our website. Appfolio does that as well. And the next reiteration that you're going to see is and it's allowable, and we've got it in our current lease form, but we're implementing it right now, is to be able to electronically provide the security deposit disposition report to the tenant electronically and not via mail. And that we can electronically pay them their security deposit refund
Yes.
electronically as well.
I saw that.
That's where the industry is going.
ACH is a good thing.
I saw.
It is a good thing. Yeah. And in our case, because of the level of sophistication, we pay, I would say 80%, perhaps higher, of all of our vendors. We do use a PO system, a purchase order system. We electronically send out a purchase order to a vendor that we want to do work. They send their invoice electronically, we process it electronically, and we pay them electronically. Yeah, it simplifies and
Yeah.
tremendous transparency. So the application to the lease has also changed. And so this is a good example on 1950.6 about the maximum screening fees.
Yeah.
And I'm going to stop here for just a moment and say to you that it's been a discussion in our office, in our risk management legal area, as well as our overall company-wide, that there is a whole of government approach, especially on the national level, regarding what they're characterizing as junk fees. And I want to urge to you regarding this provision here, that administrative fees, NSF fees, late charges, other related charges, be very, very careful, circumspect about that, because the nexus between any legal action regarding those fees is the fee that you've got set up in your company punitive in nature? And by your action, is it creating a profit center for you? Who does the fee accrue to the benefit of? And is the fee reasonably associated with the activity or actions or the cost of you doing business to provide that service? And if you can't respond to those three issues, then, and you're looking at your fee structure, just be very, very careful. There are a lot of class action lawsuits that are going on right now. That you just,
Late fees?
everything. And security deposit disposition. And I don't want to go into too much deep, yeah, the whole thing, and it's just a very problematic area that you need to be aware of, and I would urge you to make your own decisions. But be aware of the focus that's going on in the industry about those issues. Almost sounds like we're, those of you who are online can't hear it, but it almost sounds like we're under somebody's bedroom. I just thought I would mention that.
There's a pest control problem.
No, well, no. I couldn't help but say that. So, the move-in inspection report is also changed.
Yeah. Okay.
And it is much more descriptive. And, so this is another area where I would urge you to change the forms that you've been using so far. The right to inspect prior to termination of tenancy is also there. The tenant can request that the security deposit statement be sent via email. Security deposits be sent electronically. Housing providers can agree or just do it, but you need to get the agreement with the tenant. The pre-move out inspection statement goes through the same process, but this whole area is evolving. And this is again a reason why that you need to be using the current form. Before, and I'll go on to this on the Tenant Protection Act on 1482. Before I move out of this section regarding forms, does anybody have any questions regarding the forms themselves, either online or within the class? Okay. So actually at 11 o'clock was what I was anticipating, which is where we're at for that section. So I'm pleased because I want to leave some time at the end of the class for questions outside of the material that I'm doing. I want you to know, consistent with the expert witness issue that I referenced earlier, I have a trial to testifying in at 1:30 down in San Diego. So when we hit noon, I'm not trying to be rude, I just have to leave. So I will do so. So the Tenant Protection Act 1482 is the next thing that we'll go into. Let me preface this before we go into it, and I've been contemplating in November of this year here in San Diego. I'm going to be installed with the chairman of the National Apartment Association, as I mentioned, and I have a speech to give. And part of the things, as I was reflecting on the things that are going on in the industry that I'll just mention to you, is what is the driver of change that is occurring in the industry that I have felt, and you may feel as well, that we're somewhat under attack. And in my view, the two drivers of change are COVID as a primary driver of change, and the result of both the restrictions on rent increases the lack of housing affordability, and the substantial increase in regulatory activity through legislation and regulatory behavior on various agencies within government have resulted in substantial changes and why we feel impacted, assaulted by all the changes. And it's my view that we have an opportunity, rather than somebody once told me that what we resist persists. And that rather than continuing to resist that which we feel under assault by and the negative characterizations of being a landlord or a housing provider, that perhaps part of the transformation of being viewed as a landlord, but rather as a housing provider, is to provide more equality in the relationship between the landlord and tenant. And we can do that by changing the nature of the relationship in a collaborative environment, where many of the things that I've already talked about is about creating that collaborative environment where it's not us against them. It's not us, the industry, the rental housing industry, against tenant advocacy groups, but meeting people where they are and recognizing that their wants and needs don't have to be adverse to our wants and needs. So I'm giving you somewhat of a political statement of what I'm intending to talk about when I give my speech, when I'm installed as chairman. But I think that we need to reorient. So as it relates to the Tenant Protection Act of 2019, this is in response to that lack of housing availability. It's in response to what occurred and has been occurring about the lack of availability of housing and the resulting COVID and the subsequent restrictions. And now the Tenant Protection Acts and ordinances that have been put out, and the White House, and I was involved in those discussions. They just involved us, they just told us what was coming, is the Tenants Bill of Rights at the national, under the Biden administration. And they're indicating it's a whole of government approach. And again, my perspective, I think it's here to stay. It's incorporated in the new landscape, and it's our opportunity to embrace the change and see if we can't change the nature of the relationship, but it's going to take a lot of work to get there. So under the Tenant Protection Act of 2019, it provided the rent cap, it provided just cause eviction, and it provided an effective date of January 1, 2020. And it has a scheduled repeal date. So all of these are subject to a sunset provision of 2030. Candidly, I don't think that it's going to be repealed. I think it's part of the landscape that we've got. If anything, it's going to be augmented and supplemented too. So on the rent cap, the tenant's rent cannot be increased by more than 5% plus the cost of living, or 10%, whichever is less, in a 12-month period of time. For those of you who are here, we have a quick guide, which is the rent increase, and it has a formatted box that shows for the CPI increases. I will share with you that for those of you who are online, Shirley will be sending this out to you. Now, Jessica, tell me, I think our most recent information that was sent out shows for San Diego, Carlsbad, it's 5.3.
For the CPI, I believe that's correct.
Correct.
So we're up in 9 points.
Well, actually, it's 5.3 plus 5 is 10.3. So it's a little bit different than what's reflected in this guide, and that's reflective of the current inflation rate as of, I believe, March of 2023. So under the current situation for properties located in the city or the county of San Diego, it's 5.3. So 5.3 plus 5 is 10.3. And so just recognize that that's the number that we're working with in the current time. And it is within the last 12 months of that tenant's tenancy. which is really important to recognize. So it's going to continue to evolve and change, which is why you need to continue to monitor the CPI
Oh, God.
as it relates to the increases that you're providing to the residents.
How often does it change, the CPI?
Every 2 months? Is it 2 months, Jessica, or every month?
Maybe every 2 months.
I think you don't have to look at it. I believe it's every 2 months.
But you have to use the most recent measurement.
Yes,
So, the rent cap law, it probably applies to a vast majority of properties your company manages.
yes,
But for small property managers that manage privately owned homes and condos. But for me, checking the ownership, whether it's a corporation or an LLC, as a corporate member, it rarely applies to the properties that I manage.
and we'll get into that in terms of the exemptions.
Yeah.
But you're correct.
Thank you.
And the same thing for newly constructed properties that are less than 15 years old, it doesn't apply.
Large apartment complexes are usually owned by corporations.
Yes, and so they do apply, or by LLCs.
Right.
And so that's a good distinction.
I still advise owners, it may not apply. But,
Yeah,
you could be accused of gouging. If you try to increase the rent. Too much.
And so you took the words out of my mouth, because I was gonna say the same thing, and that's very insightful. If landlords want to potentially be viewed as gouging, just engage in that so that the tenants view that you're gouging because you're exempted. And you're gonna find in not too short of a time that exemption is gonna be gone. So my recommendation is consistent with what you are talking about. I would still conform even though you're not required to.
I do, I just go, I don't do this.
Yeah, I think it's the best way.
It's safe, it's, I don't get any blowback and, and I'm just, my owners are comfortable with it as well.
Yep, I think it's a safe harbor. It's a
It
good
is.
thing. So that's on the rent cap, on the exemptions, which is to your point. And I have to thank Jessica and Andy in my office, who Shirley and I were laughing about our lack of technological competency before we started the class. If I was to do this, I maybe could, but I probably wouldn't be able to. But I have wonderful staff that has the ability to make these slides look really professional, which is more than I would be able to do. So, but these are the exemptions. Again, where housing is issued a certificate of occupancy, so this is for new construction. A duplex where the owner occupies one of the units, single family home or condo, if it meets these criteria. So you're right on point, but it's important to know that those exemptions exist, and also to be recognizing that you may want to take a position as you and I do, which is just to conform. Just because it's a big safe harbor. New tenancies, owners can set initial rent at market level, and subsequent increases subject to the Tenant Protection Act. Now, I'm going to make a comment. I mentioned this before the class started. Have you all heard of the concept of cash for keys?
Yes.
Okay. Notwithstanding the limitations, and we're going to get into cause evictions. It does not preclude or eliminate the ability for a voluntary agreement to be entered into between the landlord and the tenant regarding an early surrender and possession, subject to cash being provided by the landlord to the tenant. But it has to be a voluntary agreement with that resident. Really important. No coercion, nothing that could be asserted by. Yeah, that's it. So in this current act and the way that it's set up is that there's no restriction on turnover of tenancy to set the rents at current market and based on the renovation of the units and all the rest. So then the next area that we're going to get into is at fault and no fault just cause evictions. And you can see the reasons for the at fault reasons to evict. If you're not familiar with it, by having to learn the hard way, the courts are very backed up. And being able to be heard on an unlawful detainer action, being able to be successful in an unlawful detainer action, and then getting rid of possession and then having it executed by the sheriff or marshal's office. Many of these processes, depending on the jurisdiction, are taking 6 to 9 months. So if you find yourself in that kind of situation, even though it's a difficult position for the landlord to accept, it may be beneficial to do a cash for key and voluntary surrender. I mentioned before the class started in Los Angeles area where I do a lot of expert witness work. It's not unusual for cash for keys agreements to be in the $20,000 to $30,000 range. It's significant. And I only say that to you because I don't want to incentivize people to do that. But I just want you to know that that's what's now becoming more and more common in that environment. Now, in that environment, the tenant may, under a rent control environment, may be paying $1,000, and if the unit is renovated, it could be rented for $3,000. And so when you look at the cost to improve against the increase in the rents, paying out $20,000 or $30,000 makes some sense. But I want you to conceptualize that the potential of offering more money to a tenant in order to surrender, when you think about what your rent is on a single family home or a condo, that doing $20,000 against 9 months of lost rent may be worth it.
And legal fees you'll never collect.
Right.
I did a lot of that in the short sale days.
Yes,
Right.
so you know,
I was a bankruptcy paralegal back in 2009,
good job,
so
you know,
I gave a lot of cash for keys, and people were like, "I'll take it."
yeah,
I'm
That's
out
right.
here.
that's right. So I'm only saying to you that, again, it's a bitter pill, I get that, but it may be an expedited way to solve a problem. And many times the tenants that are not paying their rents, not many times, but sometimes, they're not in conformance with the rules and regulations, they're disturbing other neighboring properties. And so the path of least resistance is to do the cash for keys and facilitate their moving out. So that's on that. No fault reasons to evict under just cause. You can see the reasons why. The tenant protection ordinance that is within the city of Chula Vista and within the city of San Diego is providing further restrictions and monetary amounts that are necessary, including that the work is going to take 30 days or more to complete. Under rent control up in, and it has to be over a certain dollar amount. Up in Los Angeles, you have to file a tenant relocation plan if you're doing work up in that area in a non-voluntary, because there's been something that's occurred in the apartment, and it has to be approved by the rent control board and approved by the tenant. The tenant can argue against it, but ultimately the administrative law judge makes that decision. But again, this is another very, very complicated area. And notwithstanding these provisions, cash for keys are still provided. You could still do that, notwithstanding these provisions.
These are the TPA requirements.
Yes.
But the city of San Diego and the Chula Vista requirements may be more.
That's exactly right, and they are. Now, the ordinance in San Diego. Was just passed initially, they have to do a second reading. And so it hasn't gone to an effect yet. The Chula Vista,
This 2 month relocation or potentially 3.
yes,
Wow.
yes, and the Chula Vista ordinance is already in effect.
And what is that, 3
3
months? 3 months relocation?
I don't recall,
Top of my head.
yeah, I don't recall,
So new.
yeah.
Yeah,
So we've already gone through this, and this goes back into the slide that we previously talked about. More just cause exemptions, single family owner occupied residence where the owner and the tenant share a bathroom or a kitchen. This creates an interesting area with roommates.
yeah.
It really does. It's just, it really is more complicated. One thing before I forget on applicable forms and these different forms that the change in terms of tenancy, notice of termination of tenancy, to perform covenant or quit, those have all changed. And on the materials that Shirley sent to you, online, and those of you who are here present, there are a number of documents which are quick guides from the California Association of Realtors. My recommendation to you is that if you have, let me just see a show of hands of the people that are here. How many of you have gone into the section of legal Q&As from CAR? A couple of you have. I use it regularly.
Love that thing.
It is one of the best tools that you can use. If you have a question about anything, being able to go online to look at the quick guides or the legal Q&As, and they're set out by category, so you'll see landlord and tenant. It's the same thing for transactional work. Before you call the legal hotline at CAR, look at these legal Q&As and these quick guides. They are outstanding.
And if you can't understand them, you just pick up the phone and call the hotline.
Then, yes, that's right. And we created the hotline when I was president of CAR back in, I was president of CAR in '96. Think about how long ago that was.
Wow.
Yeah. Well, I was the youngest president at the San Diego Association of Realtors. I was 29. And I was the youngest president of CAR at 30. So I was just a baby.
I remember those days.
We all, and the fact that we can remember is the best part. So, yes,
So the COVID pandemic helped bring along TPA and some of the.
Yes.
But there were also COVID restrictions that occurred, but I think most of those have expired.
yes, yes.
And we're left with the AB 1483 and the TPA. That's.
Yes, that's a good thought. And let me just supplement that by saying, and one of the reasons why I say the driver of change that is impacting the rental housing industry. And you please be my laboratory test subject about what I'm about to say, is we didn't see the level of activism of government overseeing and impacting on our personal lives to the degree that we're now experiencing it, that we experienced in COVID, that we didn't experience prior to COVID. Fair?
It was a changing event.
It was a sea change. It was one of those, in much the same way, for those of us who have been in the industry for a long time. In the Clinton administration, when they changed the underwriting requirements, where they would have if you were breathing and alive, you could qualify for a loan, helped to fuel the crisis in 2008
Yes.
of what happened in 5, 6, and 7. Right? If they used to say, if you could fog a mirror, you could get a loan. That was a regulatory sea change that precipitated, in my view, the crisis that occurred in 2008, 9, and 10. In the same way, the sea change that occurred was COVID, and then the response of government to COVID. That the housing shortage was always there, but then they, in my view, singled out the rental housing industry with a cap, and precipitated a lot of changes that are continuing and accelerating in the current environment. And I think it's a dramatic change. I tend to look at human behavior as a pendulum, that you go from, and this happens politically, that it swings too wildly. But when you think about a pendulum, it ultimately creates an equilibrium. But then something will push it again, and it'll swing widely the other way, and then we'll seek that equilibrium. But every time you introduce a new substantial change to the environment, you change that equilibrium. That's what I argue happened with the financial crisis in 2008, and that's what's happened with the rental housing industry and society as a whole with COVID.
You know, inventory and affordability has also led to homelessness, which is, I think, also a driver.
That's one aspect, and I'll just make my own comment. In the Reagan administration, with all good intentions, eliminated public mental health facilities. And it was with all the good intentions, because some of the conditions in those mental health facilities were deplorable.
Yes.
And I think his heart was in the right place, but it was misplaced, because now we've had this whole series of laws that have been enacted where families are beside themselves with the inability to protect their loved ones from their mental illness. And one of the things that mental illness creates is self-medicating, and that's the drug use that goes along. So you have a lethal, truly, with fentanyl, a lethal combination of mental illness and drug use that one of the reasons why homelessness has not been successfully addressed is because of mental illness and drug use. But now with the increased density that is has been enacted at the state level, so it's transformational. If you've driven through the North Park area as an example, in the Hillcrest area, it is transforming that area with increased density and decreasing on parking requirements. And so I think we're going to start seeing an increase in housing affordability. But the gentrification and some of these older properties that are being torn down were at lower rents, and the newer properties that are coming in, even with inclusionary housing, where a certain number of units have to be affordable, is going to be insufficient to meet the housing needs of affordable housing that is needed in the community. But we'll see how that happens. But we've got a lot going on in front of us, a lot. But I always try and think about, and then I'll stop on the philosophy issue, is how, much like I want the tenants to feel engaged and collaborative with creating their own solution and not being told what they have to do. I always think I don't want to be in a position for myself or my company where I'm at the effect with an E of what's going on in the environment, but how can I affect with an A the environment to benefit what I call the stakeholders involved in the company, which goes from ownership to the resident. And so I think if we change this equation and embrace the changes, I think at the end of the day, we're going to be better off. And that's what we want to be. So one of the things that we often do, and that I would encourage you to do, is that these areas are so complicated that if you're questioning how it applies in your particular situation, and your owner is relying upon your expertise. And then making a decision based on what you're recommending. You could, if it goes sideways. You could have a problem. And so one of the things, because I grew up in a real estate family with my dad being in the business. That's what led me to get involved in this industry. He said to me when, here I am 18, my first transaction was when I was in high school. You can believe that. And he said to me, and it was very wise advice. You're not supposed to know everything, but when you're new into the industry, you want to try and project yourself as being a professional. Don't make stuff up as you go. If you don't know, then you tell the client you don't know, but you'll get the necessary information from a qualified professional so that everyone is making an informed decision. That's where the attorney comes in. Again, this may be a paid advertisement, but I'll make it anyway. There are a number of attorneys that specialize in nothing but landlord-tenant law. One is Kimball, Tyree, and St. John. And but there's other ones. Mark Feinberg is another one. But there are a number of other firms that are out there that do an excellent job. And sometimes if you've gone through the steps of based on your own knowledge, the class that we've just done, the forms that are provided by CAR, by the legal Q&As, even the legal hotline, if you need to on your particular situation, pick up the phone and that consultation is worth the $300 or $500. It just is.
I've used KTS for 25 years.
Okay, so you know. So I'm speaking to the choir. Yeah, okay, good.
And free advices, you know.
Yes, it is. Yeah. So, as I just said, in the legal Q&A, and you can see this, if you go onto the homepage for CAR and you go into risk management, legal Q&As, and then the disclosure charts and the landlord-tenant folder, it's on the equivalent of speed dial for me. It's where I go. It's the foundation that I use for the opinions that I render in a expert witness case. It is invaluable. And where are we on time? Look at that, 11:30. I just want you to know that when we set this up, and I told Shirley that my intention on this was to be done at 11:30 and to allow for questions. I don't know how we did that, but it was absolutely, from my perspective, perfect. So the forum is open, well, for the people online, again, using the chat function. If you want to pose any questions to Shirley and she'll ask the question on your behalf. Or if you guys, if anybody has questions, now's the time to do it. So, yes.
The notices, used to be 30 under a year, 60 over a year.
Right.
But now there's been some changes to that. Can you kind of summarize what those changes are? I know there's a 90-day requirement now too.
Yeah. Jessica, do you want to do it?
Yeah, that's fine. So, for our changes of terms of tenancy, you have a tenant that is on a 1-year lease.
Why don't you come back here, Jessica, just in case I can't hear you.
Within my notes, thank you. So for changes of terms of tenancy, for any tenant that you've had in residence for 12 months or more, or if they're just on a 12-month lease, they are entitled to a 60-day notice to change the terms of their tenancy, which is going to include lease renewals, or any other things that you want to add on to a new lease. It does not include rent increases. You can do rent increases separately as a 30-day notice for your tenants that are month to month. Okay, but on the other side of that, that 60-day notice is going to come in for your tenants that are on a lease, and then you want to renew their lease with a rent increase. Okay.
But if they mutually agree to an extension for a year with a rent increase less than that time frame, doesn't the mutual agreement?
No.
No.
So it's the total duration of their tenancy, irrespective of what the lease term is. So in other words, it's from the commencement of when they occupy the property to the future. So if they're over 12 months, they're over 12 months.
So you can extend them, but you may not be able to raise their rent for 60 days beyond the notice that's made.
So,
What does that mean?
okay, this is
I-
how we do it in practice,
Right.
okay? So in practice, we have a tenant whose lease is
Expiring.
expiring.
Right.
We like to 90 days before that lease expires. Say, this is our offer, this is our lease renewal offer, these are the new terms of the new rent rate. Please provide us within the next 30 days, your response, if you would like to renew your lease for another year. Or if you would like to stay on as a month-to-month tenant with this now increased rent rate, or you're going to vacate. Okay, so we're offering them that's their 60-day change of terms of tenancy. Does that
We're
make
using a
sense?
tickler of 90
You're
days.
giving them
Yeah,
90
we
days.
do.
But you
Exactly.
We have
start
at
at 60s when they have to make.
Yeah, and we do that for a reason, because we do ongoing comparable market studies of rents.
Mhm.
And we want to incentivize tenants to stay. And so we'll identify a rent rate that is below what we perceive to be market. And also conditioned on, as we talked about, the rent cap. As an additional kind of filter, restriction on the rent amount. But, we like to give 90 days notice so that they have 30 days in which to contemplate whether or not they want to renew or not. And to go out and look at the market and see that the rent amount that we're projecting as being the new rent amount is reasonable. And that they will not be able to replicate somewhere else.
Right.
I do.
And so it's just this is another example of best practice.
But this is sort of, you have large apartment.
Yes, we have single family too.
But
But
it's a different model, I think, in some ways too.
you know, but the model works
I
in
do
both
the
the
same
same way. It works in the
I've been
same
doing it
way.
for years.
Do you, sometimes I think it's better to let it lease expire and automatically roll into month to month. Because I think it empowers the landlord to have more options. And I rarely have anybody move anymore.
Okay, so what you just stated is a business strategy. So now we're moving away from what the requirements are imposed to a business strategy. I've had this discussion in our own company about that. And from my perspective, if we're going to create more balance in the relationship between landlord and tenant, I agree with you. It's better just to have month-to-month agreement. A month-to-month agreement works even at the inception of the tenancy. If you're not, if demand is constant and you have sufficient demand to rent the apartment, where it becomes problematic is where you're offering an upfront incentive rental concession to move in. If you don't have a longer term lease, then you could have a situation where a tenant could move in, taking advantage of whatever that rental concession amount is, and then simply vacate.
In this inventory situation, is not, I don't think it's gonna change for a long time.
I would
Because
agree.
these kind of changes are super tankers that simply take a long time. The rental concessions are minimal if non-existent from the landlord point of view. So, the model of month to month, I think is good.
Got a question?
Rule of thumb, when renting to roommates, who's responsible? What happens if one doesn't pay?
Okay. So I just got this question from an extended family member who lives in Utah, with a similar question. In the landlord-tenant environment, roommates are probably the most problematic nature of tenancies. And unfortunately, it's usually the younger population, which are not as stable. I'm looking for the proper way to describe it. They're not as stable as others, and you like them to begin with, and then things happen and the relationship goes sideways. The way that we approach a roommate situation is, and it's even in our lease agreement, that they are all responsible for the security deposit. And so if you have a roommate situation where someone doesn't pay, then the other tenants are jointly,
Separately.
Separately.
yes,
Usually I make it so that one person, one payment is made, not partial. payment.
well, you can, is that legal?
Uh,
I don't know, no, I don't think so, but, I don't think so, but the rent is still due.
Right.
Because somebody has not paid, and that would impose that liability on all of them. The other situation that is consistent with this question, and I'm glad the question was asked, is what if one tenant wants to move out and another tenant wants to move in? In that situation, we look at it that the issue of the tenant moving out, we're not going to return their portion of the security deposit to them. That's something that the roommates have to work out.
Absolutely.
And the original tenants, including the departing roommate, still has liability under the security deposit. We're not going to release them from that liability. The new tenant coming in will have to pay a security deposit, but that's amongst the roommates. They deal with that.
Work it out amongst themselves.
They work it out amongst themselves. And then where it gets really tricky, and this is where the advice from an attorney is helpful, is where one tenant, a roommate, refuses to move out, refuses to pay, and they're being disruptive in the apartment or the house. And then the other roommates are calling us saying, you need to evict this person.
And he's not on the rental agreement.
And that sometimes happens too. And so what we say to them is, I'd like to say, nice try, but this is a problem that you guys have. And ultimately, you may need to end up terminating tenancy, and you all will have to vacate if you have this problem. Yes, another question.
I have a couple of questions. Can a deposit be increased to compensate for inflationary costs?
No,
Next question, when repair issues arise, do you guys use a handyman or a contractor to reduce liability?
okay, so now this is a really good question.
Yeah.
The contractor's licensing board, so I don't want to get too far into the weeds, but you're supposed to have a contractor's license if you're performing services that are greater than, I think, $600.
Right.
How's that for me knowing that without looking at it? Yeah, $600. Do properties regularly use a handyman for services that are under that $600 threshold? Yes. But what we do in our company is we require those individuals, they're either our employees
Yeah. you could be all-
or that they have workers' compensation and general liability. And so we make them show that evidence. I know that not all owners do that. And you should be aware that certain requirements are imposed on owners of properties that you may not even be aware of. Cities are now taking the position, they've always had it, but they're being more aggressive about it. That if you're replacing a water heater, which involves replacing the gas line, as an example, where it's a gas water heater, that they're requiring a permit. If you replace the windows on the outside, they're requiring a permit. I don't know if you know this or not, but if you have a property that is prior to 1978, there's a presumption that those wall surfaces may contain lead.
Yeah.
So if you're going to disturb that wall, you need to have lead testing. There's also a presumption, irrespective of what used to be 1981, that with asbestos, that because of the drywall mud that's been coming in from China, the drywall doesn't contain asbestos, but the mud sometimes does. And so there's a requirement to test for both lead and asbestos.
Is this a year on there?
On the asbestos, if I recall correctly, it was 1981, but on lead,
On the drywall,
it's been that way forever.
oh,
Yes.
Oh,
And I, in conversations, and this from an industry, and I should, let me just finish with lead, it was 1978. So, unless it's an emergency, we're just automatically testing, and if we're gonna get a permit and we're gonna be doing a bathroom and kitchen renovations, we're automatically getting testing for the wall surfaces,
regardless of the year.
regardless of the year, for both.
Okay.
Yes.
Can a real estate licensee list their own property as a rental on the MLS? I suppose there is no need for a rental lease listing agreement.
with themselves, probably not.
Yeah, so, can they? Yes, on the MLS. I believe that under, because I'm dealing with CRMLS and professional standards all the time. I believe in order to use the MLS for a lease listing, and this goes to the same thing for a transaction on a for sale, you have to have a written agreement authorizing.
Yeah.
So, I'd have to pose that question to the CRMLS, but I think the real answer is that you need a written agreement, even if it goes with yourself.
Even when it's your own.
Yes, and part of the issue is. You're a principal in one capacity and you're an agent in another capacity. But in order to do an authorization, especially when you're doing a compensation agreement potentially with another agent, this is the argument, is that you need that written agreement authorizing and then putting it into the MLS. Whoever's asking these questions are the people that are asking these questions, not that the ones here are not asking good questions, but these are excellent questions.
Probably a disclosure
That's it.
requirement. too.
I wanted to kind of just add something
Sure,
quickly
please.
to the question that we had earlier about the roommates with one roommate. I believe it was one roommate wants to leave, the other roommate wants to stay. It's complicated if we're, in a 1-year lease, but once we're in a month-to-month lease, what we're seeing right now with courts in San Diego is that if one roommate wants to leave and they've given their roommate a 30-day notice to leave, that the courts are allowing that roommate to leave on that 30-day notice.
That's what you're experiencing.
Mhm.
That's
So-
helpful.
Yeah, so there is a little bit of a shift, so, keep in mind with that idea, how hard you want to dig your heels in as far as, having this roommate, attached to the lease. And then regarding the forms, there's a note that all of your leases should have language now, regarding just cause and rent gaps. So review your leases. You might see it as it was codified, as California Civil Code 1946.2. So that's what you'll be looking for in your leases, that you've got that language in there, California Civil Code 1946.2, and whether the property is exempt or not exempt. You'll probably want to have look at your leases and review that language.
Actually attaches to the packet and you set that up.
It's good, but people are using different leases, so they can have their own leases.
If you use it, You're fine, but I think that the point that. Whether the property is exempt or not, I think having the language in there is
Oh, yeah.
important.
Mhm.
That's the bottom line.
Yes.
Yeah.
The other small point is that if you are, I think I heard somebody say earlier that they're writing up their own forms and notices, which is fine. If you are doing your own performer quit notices, payer quit notices, very important to make sure that that language excludes Saturdays, Sundays, and judicial holidays. So when you give somebody a 3-day notice to pay or quit or to perform or quit, the language on that notice must say 3 days excluding Saturdays, Sundays, and judicial holidays. It will
Again,
get kicked out of
don't use your own form, use CAR's forms. And the reason that,
Saturday, Sunday, and judicial.
Correct.
yeah, and the reason that, Jessica knows this stuff in all the peculiarities more than I do, is all the unlawful detainer actions that we do go through her. So she works in our case with KTF, but she make sure that all the notices that we're providing conform to the requirements.
And it's a challenge.
So going back to the notices, 90 days,
Mhm.
I know there's a 90-day requirement, I don't remember what it's.
Oh,
for.
yeah. what is that?
We have 90-day requirements, I believe, for HUD, for if you've got people on
Mm.
housing vouchers, they're going to get additional notice. Yeah, I have to,
I think that that's the only one.
yeah.
Yeah, another question?
So I have, some of the young tenants.
Yes.
And we were having issues with paying rent. We didn't place these tenants, they were there. We discovered.
Sure.
And it's a co-living house,
Mhm.
very interesting. We've had consistent problems with paying rent and behavior. Because
Right.
they're now infighting between them. Landlord still wants his money, but we also have, so we have, the pay or quit, but then we also have the cure or quit for your behavior. You serve them both at the same time, and if they pay, is it accepting that you're gonna keep them, or do you serve them separately?
So it is complicated when you've got those two issues, and it is a good question, because how you serve the notice there is very important. So when you have a pay or quit notice and a perform or quit notice, you can serve those simultaneously. However, when you go into court, you're really only going to pursue one claim or the other. You're either wanting to get them out because of rent, or you wanting to get them out because of a material breach of the lease. It's always easier to get people out for
Rent.
rent. So in that situation, what I would suggest is you probably want to go with the pay or quit notice, but do never accept money after you, whatever it is. If it's a performer quit notice, as soon as you accept their rent, you are saying we're accepting your
But
behavior.
it's for past rent though.
That's the same thing.
Oh, it is?
Yes.
Oh, so you can't collect.
No, if you want to pursue the eviction, as soon as you say, I want to pursue this eviction, here's your notice. You can't accept rent after that point.
But generally speaking, we don't. If we have, under your hypothetical or your real situation, if we have both issues going on. We generally just pursue the rent issue because it's the cleanest, most direct route to getting them out. And I'm gonna condition that also with, you may want to engage in negotiations with them just to get them out.
Mhm.
Cash for keys, other ways of being able to deal with it. And you're gonna have to educate your owner about why that's the preferential direct route to go. You can give a different you can do a letter saying, I want you to know, and here's how we do our letter, just so that you know, if they're in violation of the material term of their lease, they're disturbing the quiet enjoyment of other tenants. We will indicate to them, the purpose of this letter is to identify areas of behavior and activity that you're engaged in that is in direct violation of your lease. And the following things have been observed. Here are the sections of the lease that you're in violation of, and you've got this defined period of time in which to be responsive to those violations. So then the question is, can you give the notice regarding the failure to pay rent and give a separate notice, not to perform covenant or quit, but rather just to say you're in violation of these terms and conditions of the lease? Can you do both? Yes, and that's what we do. Because it's beneficial to let them know, and you're effectively communicating to them how they're in violation of their lease because of inappropriate conduct, that go after them with a 3-day notice to pay rent. That's the best way to go. Yes,
Okay, with 2 quick questions, and then you're gonna have to.
I'm gonna have to.
Yes. How much of a reserve should be collected from the owner for repairs and miscellaneous per property?
So this is subject to negotiation between the management company and the owner. Candidly, from my perspective, it depends on the volume of rents that are coming in and the needs of the property. And also, especially when the loan is due and the distributions that are going to the owner. So that if as an example, you have I'll just say a $5,000 mortgage payment and it's due on the first of the month, you're gonna need an amount in excess of that loan amount, because the rents are not only gonna always come in. And so you're gonna have to reserve at least that amount for the loan payment that's due between the first and the fifth. It's a corollary question often comes up about the authorization to pay for expenses on the property. And many times on agreements, you see that as 500 or 1,000, sometimes on large properties, it's $5,000. For non-contract related services. So it's all subject to what you perceive as the need. And when you're doing distribution to ownership of any owner distributions that are coming through.
Maintenance limit.
Maintenance limit is what I was referring to, but it's the same thing with the reserve amount, to Shirley's question.
Okay.
Last question.
You can just add it on there, rents is 32,000 per month. I don't know if it means 32,000.
No, let's say it's 32,000, that's
Okay.
fine. It is subject to negotiations between the landlord and tenant, but we find that the most important aspect is what is the timing of the mortgage payment and when it's due as to the amount that you need to keep in reserves.
Okay, and then the other, last question, a bit confused about who pays what? Property manager versus owner, mortgage, taxes, HOA, etc. What's the best way to reduce liability and work? If there is a way to minimize this work.
Okay, so I know where the question's going.
Pay mortgage or tax.
Yeah, it is my preference that all of, let's say it's a condo and there's homeowner association dues. Let's say that there's a mortgage payment, let's say that there's insurance payments and property tax payments. My preference is that all of that goes through my company and that we pay all of those services. Ooh, that's me. Cause I wanna have control. I know I have the responsibility that goes along with it, but I want that control to know that those payments are being made. That's me. But that's a business decision that you make. I'm just making that decision. So, because I have to get off to court, I hope that you found this valuable. I enjoy it.
Yes.
And maybe Shirley will ask me back at some point in the future, and
You know what I will, Rick.
maybe you guys will like that as well. So thank you for the people online, for all of you. It was a pleasure having you.
Thank you.